Sense of it all, I'm joined by Advocate Romeo Nthambeleni in studio, as well as Wikus Steyl. Of course, Wikus Steyl represents Kanya Cekeshe, and therefore we'll have to start right there. Big news coming from the announcement there by the minister. I imagine that you were still going through the processes of appealing the sentence, the 8-year sentence, 5 years effective. But how does this change the situation now for your client?
Well, indeed, big news. It's a fantastic day for the family and for Kanya. The minister is slightly off with his date on when Kanya is eligible for parole. That is in June next year. So if you subtract the 12-month remission that he's got, Kanya is well into his parole period. And I'm meeting with my parole team tomorrow. They have an urgent meeting to get everything in order and to get the documents in place for Kanya to apply for the parole based on the special remission.
What implications do you imagine? And I imagine that a lot of this you'll be processing yourselves. But what implications do you believe it will have for your application to, you had an application for leave to appeal against the conviction and sentence, which was turned down in the High Court. And I imagine you were about to approach the Supreme Court of Appeal because you wanted to overturn everything. Does that mean that you abandon that bid and actually abide with the fact that he may be released on parole?
No, not at all. It's two separate processes, and it's always been their strategy. Kanya's parole is a separate thing. We will continue with the petitions and appeals as far as we must go to clear Kanya's name, to clear his criminal record. Even if he's out on parole from tomorrow onwards, we still need to follow the legal process to clear his criminal record and make sure that the appeal is successful and that both on the sentence and the conviction.
Right. And do you feel a degree of vindication around this? Because part of your attack, not only was it on the quality of the legal representation that he got at his initial trial, but it also had to do with the sentence that was imposed on him.
Absolutely. Kanya never deserved to be in prison, especially not for so long. For him now to get this remission, it supports our cause, it supports Kanya, and it's fantastic for him that he can be released earlier. And it was part of our strategy in the background, and I'm glad it worked out, and Kanya must be ecstatic as well.
Right. And you were talking there about wanting to clear the whole criminal record. And Advocate Nthambeleni, I will bring you in here as well as we talk the criminal law aspects of it. And Wikus, I'm afraid I will not be releasing you after I ask you this series of questions because I also would like your insights as well. But you were talking about wanting to clear his record. That's important to you, isn't it? Because it has implications. Even if he's out on parole, there are parole conditions that will attach for a period of time. Whereas, if you succeed in the strategy to have it all overturned, it has different implications for his future prospects, right?
Correct, yes. And it's well known that a criminal record on your name prevents you from employment, or most substantial employment. So it's very important on that aspect for Kanya's future to ensure that he does get employment, but also to vindicate him. It's a crime that he didn't commit. He should not have been convicted. He should not have followed his bad legal advice. We should not have been provided with advice. And this is part of the process to rehabilitate Kanya and his whole life from this nightmare of a process that has applied to him. And part of that is to clear his name so that this is just a blimp on the screen and it doesn't affect his life in future.
Did you at any point, and this is the last one in this series of questions, Wikus, did you at any point seek to take advantage of the sort of olive branch which was criticized, that was extended by Ronald Lamola at a particular point where he was saying we will be assisting him in applying for a presidential pardon? And of course the questions arose as to whether he was the right person to initiate that kind of process. Did you at any point, though, separate from that, try to go the route of a presidential pardon?
We started our pardon process in February already. When I wrote to the president, I wrote to the minister, I wrote to everybody that could listen, asking them to intervene and to grant their pardon. And I sent numerous letters, documents, everything. And it's only now, in the last 2-3 months, and we are still grateful for that Minister Lamola agreed to assist in the pardon application. Although the timing is not right, the legal process should follow its course first. And I've listened to the minister, and he says they remain available for that process once the legalities are out of the way. So we will continue to engage all avenues, including the pardon, if that's necessary.
All right, Wikus, let me bring in Advocate Romeo Nthambeleni into this conversation. Where it all started, Advocate, is this process, the president exercising his powers within the Constitution to remit sentences and fines and penalties, etc. This decision by the president located for us constitutionally, and is it a decision that can be assailed, that can be overturned, or is it one of those prerogative powers that the president has?
Section 84 of the Constitution says is the president prerogative to actually act in a manner that he acted in relation to the remission of offences of offenders. And as you have correctly pointed out, unless if when this whole entire process is reassessed and you find that there is something that is against the Constitution, then an application to review the entire process can be brought to court and set aside the entire process. And you must have the basis that that was done not following the prerogative of the Constitution, that was done irrationally, not applying the law. And on that basis, if you persuade the court that the president has actually failed in exercising his powers, then that process can be set aside through a review process. And that is correct.
If there's a feeling that he was not rational,
yes.
Because even though you have the power, you still have to act rationally.
Indeed. Even if you're exercising your powers as the president of the country in terms of Section 84 of your Constitution, you have to exercise it within the law, within rationality, and then on a strong legal basis and sound legal basis. That is the basis that the court will actually look at.
All right. Advocate, I do want to keep you, both of you here a bit longer, but I do need to take a quick break. Part of what I would want us to talk about is what are the pitfalls in a process such as this one, right? Issues to do with the rate of reoffense, which we are told by the Department of Justice and Correctional Services is actually quite low. So let me take a quick break and then continue my conversation with Wikus Steyl, who is Kanya Cekeshe's lawyer, as well as Advocate Romeo Nthambeleni, who is Senior Lecturer of Criminal Procedure at Monash University.